Viewers, welcome back to the Personal Injury Law Show. You'll recall before the break that I said we wouldn't be doing the mailbag this week because there's been a recent landmark High Court decision, which is the highest court in this country. Now, it's a slipping case involving a Mrs Strong, who had to take her case from the District Court in New South Wales to the Court of Appeal in New South Wales, where she lost. She won in the first instance, she lost in the Court of Appeal, and then it ended up before 5 judges of the High Court. We've got some footage of this matter, but Mrs Strong, she fell over on the grease produced from a chip. Now, let's have a quick look at this footage and then we'll start discussing the issues, guys.
Catherine was shopping at a sidewalk sale outside Big W at the local Centro shopping centre. She was walking on her crutches when she slipped. Catherine's right crutch had hit a grease spot from a hot chip. Suffering long-term spinal injuries, Catherine sued Big W and its parent company Woolworths for negligence, claiming the grease spot should have been cleaned up. So Catherine's legal team took the case to the High Court for a landmark ruling which could have affected every slip and sue case in the country. A Woolworths victory in the High Court today would have set a precedent and potentially ruled out any future slip and sue claim. But a majority ruling of the court found Catherine Strong would not have fallen, except for negligence by Woolworths.
Viewers, thanks for watching. Now, what's your take on that story, Nuts?
Oh, look, personally I said she's gone through so much, Mrs Strong, 7 years of litigation, and to finally get a result, look, it's a great result for her. So, it's a long time in litigation.
It is a long time in litigation.
Tell us a bit more about the facts of this case.
Well, Tony, this is an interesting case. Mrs Strong was actually originally an amputee. She'd lost part of her right leg and she was on crutches.
Due to cancer.
That's right. And she was walking through a Centro shopping centre which has lots of shops in it, and she was on the pavement area beside the Woolworths, or the Safeway supermarket as it's also known, and she slipped on the grease or on part of a hot chip which had been on the sidewalk, and her crutch slipped out from under her and she sustained some quite serious spinal injuries as a result. And it's an interesting case because there was a lot of fighting going on in the District Court of New South Wales where it was first heard, and the court eventually found that the owner of the whole shopping centre was responsible for cleaning inside the common areas of the store, but in terms of the area outside and around Woolworths, they found it was Woolworths' job to implement a cleaning system.
Just, can I stop you there? Monsieur, how many cleaners were on duty at the time?
For Woolworths or Centro, Tony?
Just in general.
Well, for Woolworths, basically, there was no cleaners. It was found that they had no system. There's just really an ad hoc system where if they see something, they pick something up. There's no dedicated cleaners.
And Centro?
Centro, they had rostered or registered cleaners, and between 1 to 2, depending on, I suppose, the time of the day. But they had an actual dedicated cleaning system. And luckily for Mrs Strong, that she slipped in the Woolworths part of the premises and not the Centro.
But the Centro people had 2 cleaners on, but one was at lunch.
That's right. So I suppose it's a little bit misleading that they did have 2.
Now, a lot turned on the issue of the time when she fell and when the chip could have hit the ground.
The key issue in this case was that basically how long had the chip been there, and was it, if it had been there long enough, was it the cause of the accident, and was their inadequate cleaning system the cause of Mrs Strong's injuries? And that really was the central theme of this case.
That's
what did
right.
the District Court say, Alice?
Tony, the District Court found at first instance that the complete failure by Woolworths to have a cleaning system was enough to cause Mrs Strong injury, because unlike in Victoria, and also in New South Wales, the system is based on showing that the failure of the defendant to have in place an adequate system causes your injury. So she had to link it back to the fact that they had no cleaning system. Interestingly, Woolworths didn't dispute the fact they had no cleaning system. They basically admitted that, but they said in the District Court of Appeal, and Woolworths lost, that they didn't need the cleaning system, that no one could tell how long the chip had been on the ground, and therefore they didn't cause her incident.
And there was a lot of debate about the probabilities as to when it fell on the ground.
That's right, and how they could detect it.
Why did the Court of Appeal overturn the District Court's decision? What was their logic?
Well, they felt that it'd be logical that the chip fell within, I suppose, a 15-minute period of when she slipped. They thought it was lunchtime, high traffic area, people eating, going to have hot food. That's probably when it fell. So, look, it was a generalisation, I suppose you could say, and that's how she went down.
In fact, the High Court said it was speculation because they said there's no reason why the chip couldn't have fallen between 8 o'clock in the morning when the centre opened and 12:30 when Mr Strong fell.
That's exactly right. It was
Whereas
a guessing game.
In the Court of Appeal of New South Wales, they were trying to say that the chip fell probably in that 20-minute period between 12:10 and 12:30.
That's right, and it was one of those things for the Court of Appeal. They were particularly preoccupied with the fact that the chip probably fell pretty close to the time that Mrs. Strong came along, and therefore how could Woolworths be expected to detect it before she came along? And that's why she lost in the Court of Appeal, because they said that the failure by Woolworths to have a cleaning system had nothing to do with it, and that it didn't cause her injury because they couldn't say one way or another how long the chip had been on the ground.
So,
I suppose it's a message to, I suppose, our viewers that, you know, when you do slip somewhere, you know, the unfortunate aspect of a public liability case is that doesn't mean that, you know, someone's negligent. It's all about the cleaning system.
well, the real
and how long
problem.
things
The
have
real
been there
problem
for.
is that until you get advice and your lawyers go through the process of commencing proceedings and discovery
That's
to
right.
work out what cleaning systems are in place
Yep.
and whether they're being adhered to, because that's very
Yep.
important. You'll never know if there's negligence.
That's right. You don't know until a little way into your case. It's a discovery game.
Yeah, and the key, I suppose, documents is either footage, rosters for cleaning companies, obviously incident reports as to when it happened, and those are the kind of things that, you know, your lawyers can then determine what their system's like and whether they've breached
I think
it.
the witnesses are very important too, because there's been a lot of instances where people go into a shopping centre, a Safeway, Coles, whatever, and they've been in the shop for over an hour. So they've passed the area where they fall,
right.
and the length of time is pretty significant too, isn't it, Alice?
That's right, it can be in a lot of cases. But Tony, it's important to note that you won't always find out how long that whatever's on the floor has been there, because often it's not written on the incident report, and witnesses can be really important in that
That's
regard.
exactly right.
Yeah.
But this is a very common sense approach by the High Court, isn't it, Nuncio?
Look, I think it's a great decision, because obviously I think it confirms, I suppose, all the principles that were out there already, but it does, I suppose, give a little bit of leeway in the sense that if you're not exactly sure how long something's been on the ground for, you know, it's
Then
not
it falls back on the cleaning systems.
That's right. So I think, it's a really good result for plaintiffs out there.
And there's no floodgates argument here, is there, Alice?
Look, I don't think so. I think, Tony, at the end of the day, it does lighten the load a little bit for plaintiffs, because they don't have to show unequivocally how long or not something's been there. But it really puts the
But it
onus
does
back
put
on
the
the
onus back
defendant.
onto the occupier to
That's
ensure
right.
that they've got good systems of inspection and cleaning.
And that's right. The message from the High Court was that Mrs. Strong was successful because Woolworths couldn't show they had anything in place to avoid this kind of thing happening.
Look, it's probably just quickly, Tony, it's up to now, I suppose, the shopping centres, supermarkets, whether they want to spend the money to get a dedicated system, and that's a decision for them now.
That's right.
Anyway, viewers, this is a topic that we might have to do in another episode, but one of the things I want to highlight is that with the medical negligence part of the show, please make sure that when you go to a doctor for treatment, they've got the requisite expertise, number one, and two, make sure you ask a lot of questions of what you're worried about. Pertinent questions, because that's what the courts are interested in.
Very cool.
And have a witness with you. But it's just very, very interesting when you're dealing with these areas of law. But viewers, I want to thank you for watching, but remember, go to the pishow.com, our website. Also, go to Facebook and Twitter and send us in your questions, because we do want to answer them, and the mailbag will be back next week. I want to thank Nuncio and Alice for being on the show.
Thank you,
for
Tony.
your
Thank you,
able
viewers.
assistance.
Thank you, viewers.
And viewers, in the meantime, stay tuned and please stay safe. Thank you.